Well, I'm pleased to welcome all of you to the second panel of this really fascinating symposium. Since time is in fact of the essence, I will rely on the fact that the program includes not only the names, but photographs and copious um, evidence of the eminence of the three speakers. So I won't take the time to go through that. Um, One of the frustrations, I think, with many symposiums is that excellent papers are prepared and then the speakers are told, well, condense it to as few minutes as possible. So given the tyranny of the clock, I do hope that each of the three can confine his or her comments to 15 minutes. I have prepared a comment that is now up to 8,000 words that I look forward to being in the Wisconsin Law Review, but I will try to confine my own comments to 8 to 10 of those minutes in order to have some time for general conversation. But we'll go in the order, or Victoria, would you still like to go last? Or okay, so Lori first, then Victoria Nurse, then Ned Foley. So with no further ado.
All right. Hi, thank you so much for joining us here this morning. It is a delight to be back. I am a University of Wisconsin Law graduate, so it's always a treat to come home. And I'm going to talk today about the regulation of presidential, specifically elections. As Dan mentioned this morning on the first panel, there is a little bit of a tension between the regulation as betwixt the federal government and state governments, specifically about the regulation of presidential elections. There's a lingering dispute about what authority, if any, Congress has to regulate the nuts and bolts mechanics of presidential elections once a state has decided to use that method of appointing their electors. And as we'll see, this gap exists, or this dispute exists, because of a textual gap in the 1787 Constitution. And it's emerging as an important issue right now for several reasons, one of which is Arizona has been very insistent on its right to regulate presidential elections as it sees fit. Now, Congress's power to regulate presidential popular elections has been aptly defended in court and in scholarship under both the Necessary and Proper Clause and the Reconstruction Amendments. And this paper does something slightly different than that. What this paper does is argue that there is even a more straightforward and direct source of authority or justification for congressional power in this area, and one that in fact has been accepted by the Supreme Court repeatedly in related contexts and is consistent with the underlying constitutional scheme in the original Constitution. So starting with that gap, the textual gap. So as Dan mentioned, there's three primary clauses in the original Constitution that divvy up authority over federal elections as between Congress and the states. And the first of these, the Elections Clause, gives the time, place, and manner authority over congressional elections for senators and representatives, to the state legislature, but clearly gives textual authority to Congress to make or alter those state laws in whatever ways it sees fit. The Qualifications Clause in Article 1, Section 2 speaks to the House of Representatives. The senatorial amendment later applies the same language to the U.S. Senate. And what this says is it gives to states the power to choose the qualifications of voters who gets to vote in congressional elections, as long as those qualifications are the same that the state uses for its own largest elected house within the state. And then lastly, the electors clause, which we're all now familiar with, which gives the states the power to decide how the manner of appointment of its presidential electors, but is silent on the regulatory authority it over presidential elections if a state should choose to use a presidential or popular election as its method of choosing electors. So the question arises of who gets to regulate in the gap that these texts leave about who gets authority to regulate presidential elections if a state chooses that method of selecting its electors. And what's happened is Arizona has insisted that the answer to that is that it's Arizona. And this litigation with between Arizona and various parties about congressional versus state authority in this area is about the documentary proof of citizenship at the point of registration. And they've been litigating this issue for a very long time. Arizona argues that it should get to require specific documentary proof of citizenship before it allows voters to register to vote. There is a federal law, the National Voter Registration Act, that says in contrast that at the point of registration, voters don't need documentary proof of citizenship. They can attest and avow under a penalty of perjury that they are US citizens. And then that law also includes subsequent checks on the back end with different databases. And Arizona lost that fight in an older case called Intertribal, in which the Supreme Court said that for congressional elections governed by Article 1, Section 4, that Arizona has to accept the congressional form, the federal form, that doesn't require documentary proof of citizenship at the point of registration. So Arizona took that loss, and what it did was it developed two separate registration systems. One system that it uses to register voters for state and local elections, a different system that it uses to register voters for congressional and up until recently presidential elections. What happened this summer was Arizona argued up to the Supreme Court that it could apply its state and local law, not just to elections for state and local office, but also to elections for president, for the popular elections for president. In other words, what Arizona was arguing here was that it can run two different registration systems, one of which applies to congressional elections, the other of which applies to state, local, and presidential elections. And its justification for saying it had the power to do that was the text gap about regulatory authority in those areas, combined with the argument about enumerationism. And any of you students in the room who have David Schwartz as your constitutional law professor are going to know this language quite well. Enumerationism is an idea that even if you don't know it by that name, you certainly are well familiar with the principle. And the idea here is that under our constitutional system, the federal government can only exercise power that is given to it by the Constitution, whereas states have reserved power and can do anything that the Constitution doesn't affirmatively take away from it. It's a well-accepted concept of how our constitutional system operates. And what Arizona argued was, in the face of this textual gap, enumerationism fits in. We, the states, have power to regulate presidential elections. Congress does not have that authority. And what this paper argues is that even what Arizona misses here is that there's also a longly held and widely accepted exception to enumerationism in regard to the certain powers that states do not reserve. And that is the idea that states have no power over areas which, and this is quoting Justice Story, exclusively spring out of the existence of the national government, unless those powers are expressly delegated to them. So in other words, there's one subset, there's this one area where the presumptions of enumerationism are flipped. Instead of saying if the Constitution doesn't give states the authority, what in this flipped set of situations, what happens is that the delegation has to actually be affirmatively made to the states. And that exception applies in scenarios where the states couldn't have reserved a power because it wasn't a power that the state had in the first place at the time of the Constitution. The argument of the paper is that power over popular presidential elections, once states choose that route of choosing their electors, is just such a power. The Electoral College is completely a creation of the federal Constitution. States had no authority at all in this realm until the Constitution was enacted. They couldn't therefore have reserved any authority. And therefore, the presumption of enumeration doesn't exist. And in the face of a textual gap, Congress is fully authorized to step in. I won't talk at length about the cases in order to stay on our time frame here, but the Supreme Court has recognized this in various forms for more than 100 years, or almost 100 years. Most pointedly in Burroughs v. United States, which involved a presidential election, and the court was very clear that enumerationism's limits don't apply to presidential elections once that process is chosen, because the electors exercise federal functions and Congress undoubtedly has the power to regulate and protect itself in that area. The court also made a similar holding in a less on point case in U.S. Term Limits v. Thornton, which was not directly about presidential powers, but which the court also made clear that the power over federal regulation or federal elections did not pre-exist the Constitution of 1787, could not have been reserved, and is not delegated to the states. And then much more recently in Trump v. Anderson, the immunity or the disqualification case that was talked about earlier, where Chief Justice Roberts says that in the context of a presidential election with its uniquely important state interests, the states did not have reserved powers to exercise in that area. That holding or that understanding that the delegated powers, the enumerationism doesn't apply here, those presumptions don't apply, I argue in the paper is fully consistent with the original scheme. And the reason that power over federal elections was divided up the way it was in the original Constitution, because that original scheme was very soaked in concerns that if states were allowed to control federal elections, that what they would do is manipulate the electorate in order to generate specific preferred results in presidential elections. And that allowing Congress rather than the states to have authority over the nuts and bolts regulation of presidential elections, once a state chooses that method, is consistent with those underlying ideas. Thank you.
All right, how do I move on? I still have the old PowerPoint? No, where's my PowerPoint? Sorry.
Spoiler alert. Oh.
All right.
There we go.
I'm so delighted to be here. I taught at Madison for about 15 years, and I always love coming home to such a rich intellectual experience. But I have written a very small and modest piece about textualism and the Anderson case for the law review. But since I knew there'd be a lot of students here today, I wanted to give you a little bit of a lecture I gave in London, and I'll probably give at UCLA later. So it has the, terrible title of American Legal Revolution. Now that's really strong. What do I mean? Well, I study the method by which the court reaches decisions. And I would never have said this. A lot of people have talked about constitutional revolutions, but this is different. It's a legal revolution. I study statutory interpretation. I have something called the Supreme Court Interpretation Lab at Georgetown. And my view is that we need to wonder why we have gotten here. This is what happened to change my mind about this lecture. So for about 20 years, I've been thinking about the method the court uses, and I read all of their cases, and we do this in our lab at Georgetown. And it's pretty much rule of law stuff. We can argue about whether these, this reasoning makes sense. But this really stopped me. I have defended the rule of law against people who engage in critical or equal studies and a whole bunch of other things in law school for 20 years. And this stopped me dead in my tracks. And it stopped the democratic institutions that we study. And all you fancy election lawyers, you guys know so much about that stuff. I'm going to shift the temperature, but I think it's important to protect what you protect. It's important for us to know this. So how did we get here with people talking about something called the No Kings Act, which was introduced on August 1st, 2024? Well, I believe that a philosophy that is known as originalism had something to do with this, because I think if they weren't influenced by that in some way, we would not necessarily have seen that. And I want to connect it to something bigger, which is democratic decline. We know that that is happening around the world. And my thesis is that the Supreme Court has now added itself to an already undemocratic constitution, as we know from the fabulous and brilliant work of Professor Levinson. And so they're squeezing it even further. So now why a legal revolution? Because it's trans-substantive. They also decided Loper-Bright, which it constricted Chevron or eliminated it, and major questions in the regulatory field. So this isn't just about constitutional law, and that's why it's different. And that's why I am using this rather extreme term today. But it's all of a piece. And I think it has something to do, and I'm sure we'll get in a good argument about what this really has to do with how they reason. A lot of people think this is just rhetoric. But I think there's some misconceptions you should know about originalism. One, it's not about history. Everyone thinks it's about history. If you just have better history, it'll all be fine. And I love historians. My first law review article was about history. And my good friends at Wisconsin are historians, but I don't really think it's about history. It's about text. It's about semantics. And if you ask any originalist, and I work with Randy Barnett, who is one of the leading originalists, I've taught with Larry Solem, the great theorist of originalism, he would say it's about text. Why? And they shift between text and history. So in the immunity decision, it doesn't deal with any history really. And it doesn't even say much about text. But guess what? Behind it is a theory of the text based on a couple of words, which we can go into later. So I don't think it's really about history. I think it's about text, and I think they play fast and loose with that. And I also don't think it's a theory of the Constitution. So let's go on to our, I want to be quick about this. It's about ordinary law constricting the Constitution. All right, so if Congress passes a statute, if the court, decides Loper-Bright, for example, let me go back to this, they can change it. So yes, Senator Warren introduced a bill saying, no, we're going to reverse Loper-Bright and we're going to get rid of major questions. It's already happened because it really affects what they do. But what happens if they get the Constitution wrong? 20, 30 years, maybe never. So their stakes are really high of imposing an ordinary law idea onto the Constitution. 3, it's not particularly traditional. So it's about excluding evidence, not including evidence. So usually you rely on a panoply of factors. I call them redundancies because that's what scientists do to make sure their theories are valid. But precedent is one of the key judicial virtues. And you notice that there's been a lot of reversal of precedent recently. And prudence is another one. The court consistently says, and I've documented this in a long law review article, they don't care about the consequences of their actions, which I think is a rather dangerous proposition. But here's what I want to talk about today. And if you want to see some data on this, we ran a regression on the biggest database of text ever, created in the lab. And we asked whether these opinions, we use Python expressions to see whether they actually use the historical sources that originalists think they do. And the only cases are Dred Scott, the passenger cases, which are seriatim opinions. It's a modern practice. It's new. It's not old. Now, of course, then originalists say, oh, but it's text. So there's this dance that keeps going on. All right. I want to keep to my time. So what I really want to say is that what I think this is at war with is the electoral constitution. and why I wanted to give this in front of great election lawyers and people who are interested in elections and trying to protect our elections, because they're at stake now. They really are. So if we eliminate Article 3, we still have democracy. But what if we eliminate Article 1 and Article 2? We don't even have courts. Most of the Constitution is about popular sovereignty. And this is why I think we should redo our constitutional law case books to not start with Marbury. Let's start with Article 1, where the founders started. Because we give the impression that the court is supreme just by virtue of how we teach those cases. But I digress. So the key is that I believe that original effectively constricts the franchise. So when the Supreme Court imposes on constitutionally mandated voters the meaning of ancient laws as they did in Dobbs or Heller, it imposes the views of a distant minority of citizens on today's majority with the laws you're all seeking to protect. No woman voted for the laws invoked in many of the laws invoked in Dobbs. Women and people of color were not there for many of the Heller laws. But it's not only that. People have claimed that originalism is racist and sexist, but it's also minoritarian. It's not simply the dead hand, it's a dead hand that denies the power of popular sovereignty. And so what I did is I actually read the originalists and their theories, and I spent a lot of time and I teach about them. And the truth is they find popular sovereignty very challenging. In fact, they say that we are never as a group rule. They don't like groups, they think there's only individuals. And they also say that popular sovereignty only exists at the time the Constitution is amended. 1787, 1868, 1920. So what happens when we all go to the voting booth? I think this is an extraordinary argument. And I want us to stop and think about it. Maybe that's what explains the fact that this court has never been particularly worried about things like campaign finance, partisan gerrymandering. They don't care about those parts of the Constitution. If popular sovereignty only exists at those times, what does the rest of the Constitution mean? What do our election law mean? It's really a striking assumption that, as Keith Whittington says, our sovereignty is only potential when we go to the voting booth. So I'm very worried about this theory. I believe, as Cass Sunstein just wrote in his book, that it is illegitimate to interpret a constitution to get rid of Article 1 and Article 2. It's anti-textual, and it misunderstands how most constitutional disputes are resolved in Washington. I've had the honor of working up and down Pennsylvania Avenue, and I'll tell you right now, constitutional disputes, most of them, never get to the court. They're resolved every day in Washington between the political departments. Oftentimes they never can get in court because no one has standing. That's my understanding how the Constitution works. And I think we as law professors really, really need to think hard about how we have been teaching the court if we've only been teaching Article 3. Because I think that teaching Article 3 gives people the impression that when they say, oh, it is for us to say what the law is, as Marbury said, means something. Ask a president, they say what the law is. Ask members of Congress, they say what the law is too. That's a meaningless, vacuous term. But I can tell you that the temperature in Washington has changed since this decision. It's not about whether it's about and this term, because this term, I think, has been the most momentous term of my life. And I say that with some regret, because I never wanted to see this. But I do now think we really have to evaluate what we are teaching to make sure students understand the Constitution entire, the electoral Constitution. I think election law should be much more part of constitutional law than it is right now. And we have a duty to our students to tell them that the Constitution does not create an imperial court. So thank you.
Well, like everybody else so far, I'm really thrilled to be here in Madison at this wonderful symposium. And the particular reason why I'm so excited to be presenting this paper as part of this symposium here is because I'm trying to, take very seriously Madisonian political theory and reinvent it or reinvigorate it for the 20th century. So I see this paper as part of what could be considered a neo-Madisonian reform project, and I, would love to get lots of feedback on it because this paper is going to be a stepping stone to a book that's trying to, build out this approach. There's a bunch of stuff in the paper that we could talk about in Q&A or out there or over lunch or whatever, but I want to focus on one particular piece of it. So there is a little section on proportional representation, for example, and it mentions that self-districting idea I mentioned, and now I'm going to incorporate Nick's new version of proportional representation as a subset of neo-Madisonian reform. There's stuff on how to deal with the terrible malapportionment of the Senate. But the particular piece that I want to focus on is the fact that even if we got proportional representation for legislative bodies that are susceptible to that, a lot of our elections are inherently single member district. I mean, the Senate itself, each senator is a statewide race, governor's races are statewide. And so we also need to think about electoral reform that is not susceptible to proportional representation. So that's what I'm going to focus on. And the historical piece that I want to do is to link Madison himself and his ideas that were growing out of the Enlightenment and were, the product of trying to use human reason to figure out the science of politics. So coming from Montesquieu and Locke and the whole tradition of how do we think through what they would call republican government, what we would call democratic government. And while that was going on, while Jefferson and Madison and our founders, as flawed as they were trying to think of these ideas, over in France, there were another group of thinkers that were coming out of the Enlightenment who were applying, in particular, mathematical principles to the problems of voting or the problems of elections and democracy. And one of those thinkers, French thinkers, is someone called Condorcet, the Marquis de Condorcet, who was he wrote a constitution for France during the French Revolution. He ultimately died, unfortunately, under the Reign of Terror when that revolution went horribly wrong. But his ideas have been influenced in what's now called social choice theory. But there does not seem to have been in the United States a reintegration of the Madisonian views of political science based on separation of powers, federalism, divide and conquer, the problem of factions, and the theory of how you aggregate preferences that comes from the mathematical side. And so I've been looking into why was this disconnect, why was this divergence, and how potentially could we reintegrate it. And there's been some writing on to what extent was Madison himself aware of the workings of Condorcet. We know that Thomas Jefferson gave Madison a book of Condorcet's writings in his possession, but up to now, there's no evidence that he really internalized these ideas, or you may have even read the book. Jefferson wrote about some different aspects of Condorcet's thinking and so had internalized some of it, but there hadn't been any evidence that Madison had been getting the benefit of this wisdom. Well, I happen to, as part of this project, thinking about, just that we in our generation might have to reintegrate these two strands of the Enlightenment. It turns out I stumbled across a letter that Madison wrote in 1823, so long after he wrote the Federalist Papers, long after the Constitutional Convention, long after he was Secretary of State or President. He was actually thinking about reforming the Electoral College. And I had seen this letter for earlier work I had done on the Electoral College, but I hadn't focused on Condorcet or the connection. But I went back and read it to write this paper. In the middle of writing this paper, I realized that Madison had captured the Condorcet concept. And so I decided to retitle the paper and try to reorganize the paper. And feedback may tell me I need to reorganize it some more. So let's focus on that. So here's the excerpt of the letter. So just to set this up, Madison says that he thinks about the idea of a two-candidate runoff in presidential elections as a way to reform the electoral college system. We don't need to know the details, but the point was that among many candidates, let's come down to a runoff between the two finalists. And then he writes to his friend George Hay, it might be a question whether the three instead of the two highest names, so the three top vote getters, might not be a better approach, inasmuch as it not unfrequently happens that the candidate third on the list of votes would, in a question of whether either of the two first outvote him, and consequently would be the real preference of the voters. We'll come back to that language. So he's basically saying, you know, that third place candidate might actually be more preferred than the other two candidates. And then he goes on and says, but this advantage of opening a wider door and a better chance to merit may be outweighed by an increased difficulty in obtaining a prompt and quiet decision of the voters of the election. Because with three candidates before them, supported by three parties, no one of them may actually make a majority of the whole. Well, these two parts of the letter are the two essential ideas that Condorcet had come up with, you know, a couple decades earlier in the late 18th century. So the basic Condorcet principle is that if there is a single candidate whom a majority of voters prefer to each other candidate when considered one-on-one or head-to-head, that majority preferred candidate should win the election. So sometimes in the literature it's called the Condorcet winner. But as Condorcet also understood, not every election has a Condorcet winner. Instead, there sometimes can be a Condorcet cycle where A prefers B, in terms of a majority of voters favor A over B, then a majority favor B over C, a majority favors C over A, and you've had to figure out who is the genuine majority choice. So if we look back at the language of this letter, it captures those two elements of Condorcet's theory, right? The first part is the first Condorcet concept, right? If you have three candidates, it might be the case that that one candidate, when compared head-to-head or one-on-one against each other, might end up outvoting them and be the real preference of the voters. That's point one. But can we do this practically? Because given three candidates supported by three parties, you might have that Condorcet cycle where you don't settle on a majority. So this letter doesn't mention Condorcet's name, doesn't say he read the book by Jefferson, but it seems to me, reading this language, it captures the essence of the concept. So what I take this to mean is that Madison is putting a challenge to us. It would be better to have an electoral system if we could actually elect the Condorcet winner, if we could make it practical and solve the problem of Condorcet cycles. He didn't think we could do it, so we're stuck with a suboptimal system of finding just the top two candidates and have stability, but could we build a system that actually got us the top three candidates? So that's what I want to try to look at. So let's imagine an election where you do have three candidates, and we have the purple party again, but now we have blue, purple, and red. And imagine 40% of the electorate like blue the best, only 15% like purple the best, 40% like red the best, right? So the purple candidate's going to come in third if all you do is look at first choice preferences. Under Madison's suboptimal system, but the one he thinks is only practical, to figure out a winner, you have to know who would be the second choice of the voters who like purple the best. So let's just pretend this is what the split is. And then if you run the Madison's, actual top two system, you eliminate purple, and red is going to beat blue with barely a majority, 51% of the vote. And that's true whether we have a regular runoff in a two-stage electoral system or we have a so-called instant runoff using ranked ballots. But let's now try to construct a Condorcet election where we see if we can find the Condorcet winner and elect them. The simplest way to do that is just give voters a ballot where they vote blue versus purple, blue versus red, purple versus red, and see the preferences. And, and in this simplistic example, if voter preferences line up either ideologically or, in a partisan polarized world, such that every blue voter prefers purple to red and every red voter prefers purple to blue because we have this blue-red divide, then what we're going to see happen is when you just look at blue versus purple, blue's going to get the 45% that like blue best. Purple is going to pick up the 15% that like purple best, plus all the red voters who don't want blue, right? And it's going to go the other way in the opposite direction, right? Purple is also going to beat red because all the blue voters will align in a coalition with the purple voters to defeat red. And then the third head-to-head is the one that we already saw, which red beats blue 51 to 49. So the Condorcet winner in this election is purple, even though was that low, this is the Madisonian point, even though the fewest first choice votes as a kind of compromise candidate, they beat both purple and both blue one-on-one and both red one-on-one. So if you actually ran a Condorcet system in this situation, you would reach that result. But we do have to deal with the problem of the cycling. So let's just imagine a variation on this basic example. And instead of voter preferences lining up linearly in the way that we just saw, let's imagine that 10% of the red voters don't like purple second best, but like blue second best. That's going to end up changing the first outcome because now blue is going to beat purple this time around with 45% plus 10%. Do you see that? So blue's going to have one victory. The purple versus red result is the same as before, and the red versus blue result is the same versus before. But in this case, we end up with the Condorcet cycle or the three-way tie. So what do we do? It seems to me that the simplest way to resolve this tie is to look at the margins of victories or the margins of defeats in each of the three-way ties. And we see that blue's loss is the smallest loss. And so you can break the tie by saying, okay, everybody's got one victory and one defeat in this three-way competition, but blue's defeat is the narrowest defeat. And therefore, blue comes closest to being a true Condorcet winner, because if blue had just gotten a little bit more support, they would have had two victories against both opponents and would be the Condorcet winner. So it seems to me that now the science of voting literature uses an unfortunate name called minimax as this tie-breaking mechanism. There are other tie-breaking mechanisms. The way in which I like to think about this is that the Condorcet concept I think we should call convergence voting, because when there is a Condorcet winner, it means that different coalitions of voters are converging on a single candidate who is majority preferred to each other competitor. What this tiebreaker mechanism, I think, could be appropriately called maximum convergence voting, because its methodology will elect a Condorcet winner when there is one, and then it also will find the candidate that's closest to being a Condorcet winner in the case of the cycle. It's the one that identifies, it's the method that identifies the broadest range of support because it's the strongest minority coalition. And for reasons that I discuss in the paper and that we don't have the time to get into unless we want to discuss it in Q&A, I think this concept is the most faithful to Madisonian principles, given that the whole Madisonian project was how do we balance majority rule and the idea the Republican government has to be majority based with concern about avoiding tyrannies of the majority, oppressive majorities, and the protection of minorities. And I think if you understand the mathematics of this tie-breaking principle, it is the way to most protect minorities consistent with majority rule, whether we have a Condorcet winner or a Condorcet cycle. Last point, shout out to one of your own colleagues, Professor Nate Atkinson, who I've been working with on various projects, and he's got a very elegant way to visualize, which I didn't have time to put into the slides, and hopefully we can collaborate more to show even more clearly how among these three candidates, red is the weakest candidate because red's victory is the weakest victory. And so once you try to break the tie by knocking out the weakest majority victory, you end up electing the candidate, in this case blue, who had the strongest defeat. So that's the concept, and I look forward to hearing your thoughts about it.
Um, As I indicated before, I will have something in the Wisconsin Law Review titled Comments by a Cantankerous Crank about Constitutional Theory, the Supreme Court, and the Legal Academy. I do want to read the first page, page and a half, and then offer some informal comments, all within 10 minutes. I am an age and perhaps temperament when even good friends might legitimately describe me as a cantankerous and something of a crank. I am a stop to deny that because it's largely true. I want to emphasize the display of these traits is not in the least meant as a critique of the interesting and challenging papers presented us by Professors Foley, Nurse, and Ringhand. As is true of everything I've read previously by them, I've been illuminated by what they have to say, and I am sure that will be true as well for anybody reading their essays. But I do want to take full advantage of the title of our panel, which is Constitutional Theory and American Democracy. This invites reflection on the nature both of constitutional theory and what we might mean by American or any other democracy. Thus, this rather long and cranky comment, which frankly uses some of their own comments in order to connect with certain longstanding fixations or hobby horses of mine about the inadequacies of American legal education, insofar as it relentlessly focuses on the handiwork of the United States Supreme Court and thus presents a distorted picture of both constitutional theory and American democracy. So let me begin with constitutional theory. Constitutional theory far too often is treated as the exegesis of a single constitution, that is the United States Constitution. There is astonishingly little attention, except perhaps at schools like the University of Wisconsin, to the fact that the United States Constitution is one of 51 constitutions within the United States itself, and that the state constitutions differ in very, very important ways from the United States Constitution. There is also quite obviously the fact that of the 190, I think it's 191 current members of the United Nations, all but 3 have formal written constitutions of one kind or another that are also almost uniformly ignored, except perhaps in a specific subject matter case that is course that is not required and very few people in fact take. But as we all know, courses in constitutional law and too often on constitutional theory are about the single U.S. Constitution, and then the role of the United States Supreme Court as what it has called itself the ultimate interpreter of that singular constitution, so that exegesis of Supreme Court cases is the equivalent of studying the Supreme Court. So two quick comments with regard right now to the first two presentations. I think it was 1998 or so, Bill Eskridge and I co-edited a book called Constitutional Stupidities and Constitutional Tragedies. The first part of that book invited a number of our friends to indicate what they thought was the stupidest feature of the United States Constitution. And it was no difficulty getting a number of essays about that. Now, the importance of that particular part of the book, unlike Constitutional Tragedies, and frankly, a great deal of my own work over what is now probably the last couple of decades, is that it focuses on parts of the Constitution that are never taught in most constitutional law courses, because they are the structural parts of the Constitution that are never litigated. And they're not litigated, and this I'm going to touch on in a moment, because from a lawyer's or a law professor's perspective, there's nothing to argue about. There's nothing to interpret. It's putting fancy theories of linguistic theory to one side. They really are close to self-evident in what they mean. So Jeff Rosen, who now, interestingly enough, is president of the National Constitution Center in Philadelphia, selected as his candidate for the stupidest feature precisely the assignment in the Constitution of the power to control elections in the states. My own choice was not simply the electoral college that we ordinarily think of, but the electoral college system that, to an astonishing degree, we never think of, which includes the so-called contingent election. That is, if there's no majority winner, then it's the House of Representatives that chooses on a one state, one vote basis. This is insane. It's not merely stupid, it's insane. But, and then, Randy Kennedy, I think, and Bob Post both chose the limitation of eligibility to be president to natural born citizens, the stupidest feature. The point is, we focus on what I've come to call the Constitution of controversy, the Constitution that is litigated about. We never really talk about what I've come to calling the Constitution of settlement. And the settlement comes precisely from text that is thought to be, practically speaking, pragmatically self-evident. What part of 2 do you not understand in terms of allocating voting power in the Senate? What part of January 20th do you not understand? I happen to think that delaying inauguration of a new president until January 20th is also stupid and perhaps dangerous, but there's nothing to litigate about. Just read the 20th Amendment and you know when inauguration day will be. So if I have a disagreement of sorts with Professor Nurse, I agree completely and utterly with every criticism of originalism she makes. But the problem is that originalism is, or within interpretation. She talks about text, but there's a difference between the parts of the text, the majestic generalities, as Robert Jackson put it, that are litigated about, and 2, or January 20th, or 3/4, or 2/3, that sort of thing. And that's just not litigated. What the Supreme Court says is irrelevant. And we really have to address those parts of the Constitution. And We can't, because from my perspective, the worst part of a constitution that I have become ever more critical of, I think it is killing us almost literally, is Article 5, which makes constitutional amendment, practically speaking, unthinkable. Um, and so to change these parts of the Constitution would require not only amendment, but from my perspective, it would require a constitutional convention. And I am one of the very few mainstream law professors who avidly wants a new constitutional convention. Now, there's a certain kind of anomaly. One of the worst features of our system is the one that Nick pointed out earlier. That is single-member districts. Single-member districts are not required by the Constitution. They are the result of an 1842 law passed by Congress, which made perfect sense in 1842, and the reaffirmation of it, I think, in 1969, which also made perfect sense in 1969. So Congress could repeal it, but it's not going to ever. Hell would freeze over before the House of Representatives would vote for a piece of legislation that would be so completely disruptive as to require the kind of multi-member districts or proportional representation that Nick talks about. This also touches on Ned's paper, which I also agree with substantially, including his focus that if you're talking about single winners, and it's so long as we have a presidential system, we are talking about single winners, we have to think in very sophisticated ways, and nobody thinks in a more sophisticated way about this than Ned. But the awful question for Ned is why he would expect change to occur without a constitutional convention, even if one stipulates that under the moribund elections clause, Congress could do something about it. So let me conclude. I'm now at the end of my 10 minutes, but let me conclude, I hope, in 30 seconds more. I'm very fond, yes, I'm done. I'm very fond of quoting what I call Roche's dictum, which I would swear under oath I heard John P. Roche, an eminent political scientist of the 1960s, declare at a convention of the American Political Science Association during that decade. Power corrupts, and the prospect of losing power corrupts absolutely. What Ned is talking about, what Nick discussed, what Lori discusses, what Victoria discusses, all involve power and whether or not those people with power will be willing to contemplate losing it. Now, one of the things that's wonderful about a lot of American states is that they believe in direct democracy. Whereas James Madison, and I'm not the same fan of James Madison as Ned is, James Madison was not a proponent of popular sovereignty. We could talk a lot more about what that concept means. American states, many of them do really believe in popular sovereignty, initiative referendum, other forms of direct democracy, whereas James Madison, Federalist 63, held it as a feature and not a bug of the US Constitution that there's not a scintilla of an iota of space for actual rule by we the people. And that is why I think that only a constitutional convention that has the same audacity as the 1787. I don't bash the framers, I bash us for not having any of the audacity that people like James Madison and others had in 1787, where they recognized that they were being governed by what Hamilton in Federalist 15 said was an imbecilic political system, and something needed to be done about it. So I think we have